I can see people are still joining, so we'll just wait another few minutes to let everybody in. Okay, I think we are all in. A good evening and a very warm welcome to you all. My name is Samantha Knights. I'm a barrister at Matrix. I'm delighted to be chairing the first in a series of 4 one-hour webinars organised by Professor Başak Çalı at the Bonavero Institute of Human Rights at Oxford University and Professor Philip Leach at Matrix. The webinars are looking at current and cutting-edge issues in international human rights litigation, and tonight we're focusing on urgency and how and whether human rights systems can respond adequately to urgent situations. We're going to look in particular at interim measures in the European Convention on Human Rights System in the context of asylum and migration, and also how the UN Human Rights Committee addresses urgency. It's wonderful to see so many people joining us tonight. We have people from academia, from practice, NGO world, and other organisations. By design, the webinars are aimed at a broad audience, but we are looking at substantive law, we're looking at practice and procedure, as well as strategy. We've got an excellent lineup of speakers for tonight's event, and I'll introduce them in turn shortly. In terms of format, we're going to have an introduction from Başak and then short presentations from our 2 speakers, about 8 minutes each, and I will try and keep them to that timing. We have with us Professor Ellen Tigruja and Dr. Daria Sartori. And then we'll go straight into discussion and questions because we want to generate lots of discussion about this topic. So do put questions into the chat whilst speakers are speaking, and we'll aim to get to as many of them as we can in the hour. It's very helpful in this context if you can make your questions direct and short. We should also say that the event is being recorded so people will be able to enjoy it after the event. So Başak is going to begin by setting the scene and what is meant by urgency in the context of international human rights litigation. By way of introduction, Başak is Professor of International Law at the University of Oxford, Head of Research at Bonavero Institute of Human Rights in Oxford, and of course the co-organiser of this excellent series. She was previously the founding director of the Centre for Fundamental Rights at the Hershey School in Berlin. I hope her full biography will be put into the chat as a link, as with each of the speakers, so you can read it at your leisure. Başak, thank you so much for this series, and over to you.
Thank you very much, Sam, and hi everyone. It's a pleasure to be discussing the theme of urgency today, and let me just extend a very warm welcome also on behalf of the Bonavero Institute of Human Rights to those attending. So my aim is to set the scene and maybe place our discussions around urgency into a slightly broader context. And the first thing I'd like to do is just to think about how urgency is manifested in international human rights law litigation. And I'd like to suggest at least 2 ways that we may think about urgency, but I'm not saying these are the only ways. So some of the members of the audience might think that there are lots of other ways that one needs to structure and think about it. So what are these 2 ways that we could think about? I think the first one is urgency for the applicants or for the victims of human rights violations. So it is urgency from the perspective of the groups or individuals who are bringing cases. And here, obviously, the urgency is about them, but also about their immediate enjoyment of their rights or immediate risks to their rights. And of course, the range of rights can be very broad. So obviously, we may think about them in terms of right to life or freedom from torture and inhuman degrading treatment. But of course, it's necessarily not limited to these rights, even though in practice, we think these are the most salient, perhaps, situations. But I'd like to also bring to our attention a second concept of urgency that perhaps is new. So in this webinar series, we're also thinking about new and frontier questions. And this has to do with the urgency of the subject matter of litigation. So in these cases, perhaps the urgency cannot just be reduced to urgency from the perspective of the victim, but it could be even more meaningful because there is a large group of potential victims. So deciding in that case is not just relevant for the urgency of one person, but actually a much larger group of people who may be silent. So they're not necessarily applicants, but they may also be directly affected by the situation. So these are two different ways of thinking that I think it may help our discussions as to how international human rights courts and bodies handle questions around urgency. And if we look at what are the procedures, what are the mechanisms to address these issues, and of course, there are some very well-known, well-practiced procedures, and there are some new ones that may come to our attention. And of course, in relation to urgency for the victim or the applicant, interim measures, sometimes called provisional measures, have been at the forefront of thinking and also implementing this idea in real time, in real practice. And I think today we will be discussing this aspect of this procedure extensively. But of course, there are other procedures that have developed more so over time, not through by design, but literally changed over time. And of course, one of them is the case priority policies, both in terms of prioritization of cases from the perspective of the applicants, so the so-called life and limb cases, but also case priority policies by way of looking at impact cases. It's something that has been a recent development, in particular in relation to the European Court of Human Rights. And of course, sometimes urgency also manifests itself in substantive reasoning of the courts and the bodies, but this is a lot less so, I would say. But if you have read the latest or the landmark judgment, not just the latest judgment of the European Court in Verein Klimaseniorinnen versus Switzerland, you would see also in the merit stage, there's been quite an interesting amount of discussion around urgency. And finally, I think a very least developed area of urgency is urgency in relation to remedies. For example, there has been some practice where courts and bodies request immediate release of applicants from prison, from arbitrary detention, or from imprisonment, or immediate restoration of rights. We may even think about time limits, perhaps in relation to remedies in the context of how urgency manifests itself at the very end of the litigation process. But I would say that interim measures is a field that has been a lot more developed, and we have paid a lot more attention to this, and perhaps less so on other aspects of how urgency manifests and how it can be treated. So I will conclude with these thoughts, but of course, perhaps we will be hearing some very important interventions in a minute. But of course, the treatment of urgency varies significantly between one international court to another. So this is something to bear in mind if one is looking at different options in relation to litigation. So detail would significantly matter as to whether one takes a case to Strasbourg or to Geneva or somewhere else. And of course, the activism or more attention to urgency by courts and tribunals may be challenged by states, and states have challenged, for example, clear practices on interim measures or priority policies. So, pushing for more urgency sometimes may risk backlash from the state. So there's an odd relationship between states criticizing decisions and how urgency is treated with care. And of course, finally, and this may come, you might say that I'm saying the first thing I should say at the very end, but of course, urgent procedures are incredibly slow in international human rights courts and tribunals. When we're talking about this, we're not necessarily talking about days, but sometimes much longer spaces of time. So thank you, and I'm looking forward to the conversation that is to come.
Başak, thank you. That's a really wonderful introduction, and you've touched on many areas which I think we're going to come back to in discussion, including the scope of interim measures, and how far does it go beyond the Article 2 and Article 3 cases, and the relationship between interim measures and priority, and the problem of the backlog, and also, of course, remedies and enforcement, and what happens in practice when the state doesn't want to comply. But we're going to turn straight away to our first of our two speakers, Dr. Daria Sartori, who's going to talk about the ECHR system and the asylum and migration cases. Daria is a human rights lawyer registered with the Italian and the French bars, specialising in litigation before the European Court of Human Rights. She was formerly a case processing lawyer at the court and is currently the co-founder of Pro Jura and the supervising lawyer for the Rule 39 Pro Bono initiative. She teaches at the NYU School of Law in Paris, Sciences Po in Toulouse, and the Université Catholique de Lille, and is the executive director of the NYU European Public Interest Clinic in Paris. Daria, wonderful to have you here, and over to you.
Thank you so much, Samantha. Thank you, everybody. Thank you to the organizers of this insightful webinar series, and particularly to Başak, Philip, and Samantha for the invitation. It's an honor and a pleasure to be here. I'm really looking forward to the exchange with Helen and with, of course, the participants. So, as mentioned, by way of context, my main professional focus is interim measures before the European Court of Human Rights, which is a system that I know, let's say, from the inside and from the outside. I've been worked for the Registry of the European Court on a number of interim measure cases before, and now, having since 2020 been leading the Rule 39 Pro Bono initiative, which is a collaborative pro bono project which supports the correct use of interim measure requests in the interest of foreigners before the European Court of Human Rights. So I will try to give a presentation today, I hope in the limited time available, that goes to the heart of the reality of using this instrument in cases concerning the protection of foreigners from human rights violations. And happy to take any question then at the end, as was mentioned through the chat box. So, first of all, as regards the broader context, I would say that we all know that the European Court of Human Rights is overwhelmed. Let's say that the overall number of pending cases is always around 60,000 cases per year, and the cases involving the most severe violations risk being delayed, even if just by the sheer number of applications. So the court introduced in 2009 priority policy, which was meant to expedite urgent cases, but I would say that its effectiveness is questionable, because if we take an example which comes from my home country, which is Italy, it's the case Sai versus Italy, was the case of an applicant with suffering from bipolar disorder, who was detained unlawfully with no access to proper medical care. So the case clearly fell into category 1 priority because of the subject matter concerning the health of a person, and it also fell into category 2 priority because it was actually reflective of a bigger issue, structural issue concerning the detention system in Italy. But it took 2 years for the case to be adjudicated, from 2020 to 2022. So if this person would not have relied, which he did, luckily, on an interim measure in the very beginning of lodging his own application, he would have been staying in unlawful detention with no medical care for 2 more years before getting a judgment from the European Court. So this is why I personally think that, unfortunately, interim measure requests still remain the only realistic means to secure immediate protection in the European Convention on Human Rights system for the most vulnerable individuals. I think I'm giving an overview of well-known principles when I say that interim measures in the European Court of Human Rights system are granted under Rule 39 of the Rules of Court in circumstances where there is an imminent risk of irreparable harm. To be actually perfectly clear, the harm might be ongoing. So it might be a question of preventing something that is about to happen, or stopping an ongoing human rights violation. And the provisions involved are generally Article 2 and 3 of the Convention. The court is very rarely accepting interim measure requests concerning other provision of the Convention. So interim measures are issued by the court upon request, usually by one of the parties of the case, and they need to. They have, under the court's case law, they have legally binding nature. Even if states tend to forget it. The court has repeatedly stated that a violation, a non-compliance with an interim measure request equates to a violation of Article 34 of the Convention. I'm trying to go a bit quick, and we can come back if something isn't clear, but just to flag that in 2023, the court has announced some reforms about the interim measure system, which appear to respond, in my opinion, to growing resistance from some states. Notably, I really noticed the coincidence in time with, it was shortly after the Rwanda flights litigation, and a number of comments made by UK officials. So they introduced these reforms, for instance, the disclosure of the judges issuing interim measure orders, which was before was not the case, and a number of other codification of existing practices, such as an increased use of public statements, the press releases by the court to explain interim measure decisions, because normally, as a rule, interim measures by the European Court of Human Rights are not reasoned. So be it granted, be it refused, an interim measure decision will not be reasoned. But the court is using more and more the instrument of press releases to give feedback, let's say, to give a reasoning of sort on certain cases. And also another tendency that has been codified is that to adjourn the case and ask for more information. So not decide immediately on a request for interim measure, but adjourn the case, so stop the case, ask questions to the parties and see what happens. And I will come back on this because it's an interesting development. So traditionally, interim measure requests in the European court system have been used to prevent deportations. This is the typical field in which they were developed, actually, as a tool. But now we see, in recent years, we have seen a growing number of requests that have related to other topics, and I'm focusing on foreigners. So we have access to reception conditions. We have seen a huge stream of requests to tackle the Belgian reception crisis. We have also contributed with the Rule 39 Pro Bono initiative, but the work was mostly carried out by Belgian lawyers. We have seen a huge stream of interim measure requests used to tackle pushbacks at EU external borders. And I'm thinking about the Greece-Turkey border, both land and sea, as well as the infamous border between Poland, Latvia, and Lithuania with Belarus, which litigation that gave rise to the recent cases heard by the Grand Chamber on 12 February of this year. So these are cases concerning access to reception / access to territory, even though, I mean, it needs to be clarified that the European Convention on Human Rights does not per se grant access to asylum proceedings nor access to the territory. But it's interesting to see how, as Article 3 comes in play as soon as a person steps foot on the territory of the member state, when a person is in the territory of a member state, then Article 3 guarantees apply, which means in the end that this person can, should have access, if she or he or them are an asylum seeker, to reception conditions and to protection against refoulement. So turning to some challenges which I have noticed personally concerning the interim measure system before the European Court. So of course, the first coming to mind is state non-compliance and hostility in general. So one of the biggest issues I've also been facing in my practice is lack of willingness to comply, combined with the fact that in certain countries, authorities interfere with evidence collection and obstruct even legal representation. So this makes it incredibly difficult for lawyers and human rights defenders to bring strong cases before the European Court of Human Rights. And this is typical of pushbacks, for instance, but not only. Then, even when interim measures are granted, we see increasingly outright defiance from states. So, for instance, this has been my experience. I have worked through the Rule 39 initiative on the Greek border with Turkey for 1 year and a half, around 2021, 2022. And by the end of this year and a half, it was clear that Greece completely stopped to comply with interim measure issued by the court to prevent pushbacks. So civil society themselves did not want to make recourse to this type of instrument anymore. I need to run because apparently I have only 1 minute. So yes, so another two main problems I would say to be taken into account: the court's approach, the fact that the European Court is relatively quick, because I have seen interim measures issued within 4 hours. But it's true that they are relying more and more to adjourning the case and ask questions, because this allows the state to solve the issue before the court gets the chance to actually issue an interim measure, which is a form of subsidiarity, let's say. And then there is also the role that we play as legal professionals. There are cases which are weak, ineligible for interim measure, and they still flood the system. And there is also a strategic litigation dilemma. When we choose to bring to the court huge numbers of interim measure requests because there is a systemic problem, this might have negative consequences. But I can explore this more in the questions if this is something of interest. So to conclude, I would say that interim measures in the European Court of Human Rights, they are a very relevant tool. They can really change the outcome, but they are very delicate and they should be used carefully. And just a closing remark, I would strongly advise you to check out the new, the February 2025 UNHCR toolkit on requesting interim measures before the European Court of Human Rights, for those of you who work specifically with foreigners. And I will try to put it in the chat. But thank you very much, and I'll leave the floor to Hélène.
Daria, thank you. That was a very, very wonderful and concise account of some very difficult issues, and we'll come back to, I think, some of the challenges and particularly some of the strategic litigation decisions that have to be made in this area. But we're going to turn now to a system which I suspect will be much less familiar to a number of our audience, and that's the UN system, the Human Rights Committee system. And Professor Hélène Tigrouja, who is with us, is going to speak to that system. Hélène is Professor of Law at Aix-Marseille University, visiting professor at the Centre for International Law at the National University of Singapore, and highly relevantly for this evening's discussion is currently vice chair of the UN Human Rights Committee and a special rapporteur on new communications and interim measures. So Hélène, a very warm welcome to you and thank you for joining us. Over to you.
Thank you. Thank you very much for the invitation and for having this moment, also for explaining the practice of the Human Rights Committee. Actually, as you will see, I mean, there are many similarities with what Daria just said about the European Court of Human Rights, but I would say in a much less sophisticated way. So I'm just going to say a couple of words on the interim measures, but then I would like also to discuss about an element Başak mentioned in her introduction about the priority policy of the Human Rights Committee, also inspired from the practice of the European Court of Human Rights. So first, this question of urgency and how the Human Rights Committee, based on the Covenant on Civil and Political Rights and the optional protocol dealing with individual communications, addresses complaints, individual complaints that may raise an element of urgency. We have also this interim measures system, but it's very similar to the European Court. It's not in the Covenant, it's not mentioned in the optional protocol, but in the rules of procedure of the Human Rights Committee. And it's based on the practice, but what the committee tries to do now is to really put this interim measures request in a free working day timeline, I would say. So 24 hours for the claimant, for the litigant, 24 hours for the secretariat to address, to read the complaint and the interim measures request, and 24 hours for the special rapporteur to decide on the grounds of the interim measures request. So we are trying, it's again, based on the practice, but we are trying to really put and keep interim measures request in this free working days timeline. Also, very similarly to the practice of the European Court of Human Rights, no surprise that in general, interim measures are more requested in cases of removal from territory, cases of deportation, extradition, and so on. But not only. We receive quite, I would not say frequently, but we receive more and more, for instance, requests for interim measures dealing with health issue, for instance, people deprived of liberty. We also might receive interim measures requests dealing with search and rescue operations. Very recently, I will go back if we have time, I will go back to this example, but very recently we received an interim measures dealing with a search and rescue operation under the control of Malta. So we might also deal with this kind of cases. And much more recently, we are also now receiving interim measures in context of international armed conflict. So interim measures to, for instance, have more information on the whereabouts of civilians or prisoner of war and so on and so forth. So now we are receiving interim measures connected to enforced disappearances allegations or arbitrary deprivation of liberty in the context of the Russian-Ukraine armed conflict. Occasionally, we might also receive interim measures dealing with political rights. Of course, in general, we are extremely cautious, but there is a famous case, maybe you are aware of that case, the Lula versus Brazil case, where in 2018, the Human Rights Committee granted the interim measures for Lula because his claim was to say that he has an urgent right to vote and to be presented as a candidate to election. And I go back to one element Başak mentioned in her introduction. In 2018, the committee granted the interim measures, but of course, Brazil was absolutely not happy because, as Daria also explained, in general, interim measures are more seen as related to removal from territory. And here it was considered as interim measures with a really, from a political point of view, high profile and with a huge impact. Maybe another point I could say on interim measures is that as the European Court of Human Rights, there's nothing in the covenant about the binding force, but the Human Rights Committee does consider that it's related, the binding nature of interim measures is related to Article 1 of the optional protocol dealing with individual communication. So for the committee, respecting or not respecting an interim measures is a part of granting access to individuals to the Human Rights Committee and the right to lodge a complaint. But also, as before the European Court of Human Rights, some states do respect interim measures, but some states like Australia, France, etc., in general, do not, I would say, do not buy this narrative on the binding force of our interim measures. And yeah, when they decide not to respect our interim measures, it's very difficult for the committee to react or to accept saying in a decision that there is a breach of the optional protocol. Maybe final point, and then I will go to very briefly to priority element. Final point I would like to say regarding interim measures is that in general, when we receive a complaint plus a request for interim measures, it skipped the queue in the order of processing with pending individual complaints. So when we see that a complaint does have an interim measure request, we do not wait the 18 months for registering the decision, but immediately we decide on the merits of the interim measures request, and of course, if needed, on the registration element. So it's also now a strategy lawyers and counsels are using more and more, precisely to address the backlog before the Human Rights Committee, because again, it's keep the queue in this backlog element. So now I'm precisely arriving to the other element about urgency Başak mentioned in her introductory remarks about precisely the treatment in priority of cases. You know, it's not, I mean, it's really something very well known. We have backlog before the Human Rights Committee, backlog not only in terms of registration, but when the case is registered, also backlog in terms of case management. So more or less for registering a case, from the moment the complaint is sent to the Secretariat, it might take 18 to 24 months before having a decision by the special rapporteur. And then it might take 4 or 5 years before having a decision on the merits if the case is registered. So it's true, as Başak asked, it's true that indeed treaty bodies and the Human Rights Committee is not necessarily very well equipped to address urgent issues. But we tried to think, I would say, creatively. So the committee is now starting this treatment of cases in priority policy based on objective criteria, age of the victim, health of the victim, for instance, but also based on subjective elements. And I was very interested by what Başak asked about the substantive questions. Indeed, when we receive individual cases and we consider that they raise urgent and pressing questions, matters such as climate change and so on, yes, we might decide, it's a decision taken by the special rapporteur on new communication, we might decide to treat these cases in priority, just to be sure, just to try to be relevant. But even when we decide, I mean, it might take 2 years before the committee reaches a decision. So we try to have also this priority policy, but again, I mean, yeah, there's a lack of resources, human resources, financial resources. So it's extreme. I'm not sure it's very efficient to address the backlog. A thing, and that's my final point, a thing we also try to avoid when we decide about the priority of cases is, and the combination of objective element, subjective element, we also try not to follow, I would say, too subjective elements. Sometimes some authors, some applicants come before the committee and say, look, I have in 2 months elections and I want to be sure to be elected. So please decide my case because I want to have a decision from the Human Rights Committee saying that my case, my rights were violated. So of course, when we decide about priority, we try to avoid this kind of strategic use or instrumentalization of this priority policy. So I stop there because it's already 10 minutes, but I would be very happy to answer any question.
Hélène, thank you. Really, really insightful and particularly, as I say, as I think a lot of us are much less familiar with the Human Rights Committee processes and the decision making. So it's really fantastic to have your insight. We've got 1 question, 2 questions I can see already. Please do put your questions into the Q&A box, but I just wanted to, if I may, just begin with some questions which I had. The first relates to the sort of strategic decisions that go through practicing lawyers' minds when they're working out what to do for the best for their client. And we've heard from Daria how the European Court is very overwhelmed. We can see the statistics on, at least for the UK, in terms of getting interim remedies is very low. So in the 2021 to 2022 23 period, there was only a 6% of the interim measures applications were granted. So it's a pretty bleak prospect, if you like. And the types of cases, we've got the Rwanda case where interim measures were granted, and there were measures granted in the Tamil case. They're quite exceptional cases. But what do we take away from this, and for as lawyers? And is there, do we think we've got a better chance going before the Human Rights Committee? I don't know whether we know what the statistics are like there. And Daria, what do we think about the sort of very low statistics? Is it a reflection on the hopeless nature of some of the applications? Are people overusing the tool? What should we take away? I mean, maybe Daria, if you comment first, and then Hélène.
Yes, sure. Just very quickly, the impression that I got when I was working inside the European Court is that the vast majority of interim measure requests is devoid of real purpose. I mean, there are some that are clearly manifestly founded. Domestic remedies have not been exhausted. They don't have enough evidence. They're not well constructed. They are clearly out of scope. And the clearly out of scope are honestly the ones that make me madder, because sometimes I have the feeling that some civil society organizations and lawyers use the interim measure system as a kind of publicity to advance topics that are clearly not falling within the scope of the convention system, but they just want the press release on the fact that an interim measure has been rejected, because in the end they get rejected. And this is a big issue, in my opinion, and which for sure explain those numbers. It's not the only one, probably, but it's a big one. It's a big part of the reason.
Yeah, I think, I would be on the same line. I think the numbers for the Human Rights Committee are not, of course, that important than the numbers before the European Court of Human Rights. But what we are seeing more and more, it's also this, what I call this strategic use of interim measures, maybe not for the same purpose, but here, as I said, we see more and more cases with absolutely no need to have an interim measures, but because we have this practice to decide immediately on cases with an interim measures request, we decide on the registration. So now we have this very artificial interim measures request. And I agree with Daria, it's really bad because lawyers and counsels have to understand that it takes, for the Secretariat to process with those cases, it takes some hours and hours of work. So this amount of work is not dedicated to other individual complaints where we would have really strong and relevant interim measures requests. So it's really something now we try to really insist on when we then reject and write a letter to the lawyers or counsels.
Great, thank you. And a second question from me, and then we'll turn to questions from our participants, because I can see they are coming in. Another thing that practicing lawyers are thinking about, of course, is always the downsides to any particular step. And so in the context of interim measures, could there be, a negative aspect to making the application? Could it alienate the court if it's unsuccessful? Could it cause the court to look, deeply at the merits and form, a negative view of the merits, even though they're obviously not deciding the merits at that point? So you know, Dara, you touched, I think, in your talk on there being, you know, potentially being some unintended consequences of making the application. So it'd be interesting to hear both of your perspectives on that.
Yes, happy to. Sorry, Helen.
No,
go ahead,
please. I was about to say, please, Daria, go first.
Thanks. Yes, what I've noticed, I mean, in the European court system, I think this is a bit different than from the UN system, because there is a more divided path, because interim measures can be disjointed from the individual application. So, so there is this aspect to take into account. But that said, so I would say that the interim itself does not prejudice at all in the European court system the merit. It's quite independent from one the other. But there could be the issue that if you use massively interim measures to tackle a specific systemic issue, you might get the court to set their mind on a certain legal reasoning that then they will apply quickly, but they will apply all the same to the same cases they get under their attention without paying enough attention to the differences that might be in certain cases. So this is a risk that must be taken into account when one chooses to tackle strategically a bunch of cases. One should always be aware that the first case that will be brought, the one that we catch the eyes of the court's attention, will probably inform all subsequent decisions in all subsequent cases, even if they are different. So it is a risk, and this means that the first case must be chosen really carefully and consciously.
Yeah, and here indeed, the practice of the Human Rights Committee is different from the European Court of Human Rights, because the interim measures request is not a standalone proceeding. I mean, it's really related to the registration. So in one decision, we decide both on the registration and the interim measures request. And it's true when, let's talk about cases of removal from territory, because it's really the classical scenario we receive. It's true that if we register a case, because indeed in case there's a prima facie claim, grounded claim of violation of article of the right to life or prohibition of ill treatment, but we do not grant interim measures, we might assume that it's going to be difficult for the case to go beyond a non-admissibility decision. So it means if the case is registered, but the special rapporteur said, okay, I do not see the irreparable harm and imminent harm and so on, yeah, it means that the case on the merits is not that strong. Again, I'm not saying that the special rapporteur makes a sort of prejudgment, but based on the information in the file, if the interim measure request is rejected, yes, I mean, it might be quite difficult to convince the whole committee that in case of removal from territory, there might be a violation of right to life or prohibition of ill treatment and so on and so forth. So it means that the case is maybe not that strong, but indeed it goes jointly. So in general, in cases of removal from territory, when we reject interim measures, it happens that the applicant does not goes on with the application, with the communication.
Great. We've got a question from Himani Durgamohan about the time it takes and whether it's the 2 years or 18 to 19 months is in relation to the final verdict or the interim decision. And I think both of you, your presentations are clear that that's obviously not relating to the interim application. But I think there's an interesting sort of follow-up to that about what happens, you know, if the court or the committee decides to engage, ask further questions, you know, do they ever want to hear from the other side? I think in the European context, they very rarely want to hear from the government, but could they, and do they ever in practice? And so maybe a quick comment on that, and then we'll go through the other questions.
So yeah, here for the committee, when we have a doubt, we might adopt what we call provisional interim measures. So it's provisional in the provisional element. So provisional interim measures, it's, for instance, granted for 1 month or 15 days, just to get more information from the author when we have a doubt, but still there's something, there's a danger, there's a threat, or more information from the state party or observation for the state party. So we might have this provisional interim measures. It's not frequent, but yeah, it's also a way to accommodate and to give the Secretariat, the committee, but also the parties more time to elaborate on the risk and risk assessment and so on.
And Daria, did you want to comment on that?
Yeah, I wanted to say that for the European Court is very interesting because, as I mentioned, there is more and more this practice of pausing the examination of the interim measure request and asking for more information, notably from the government. Usually they ask the government. And what is interesting is that you actually see that this is meant to allow the government the time to remedy to the situation before the court is actually required to say something, to decide. So I've had cases in which the questions asked to the government after an interim measure request was paused, the examination, were so precise that they were actually giving guidance to the government of how to remedy and avoid that the court needs to arrive to the point in which they have to issue an interim measure request. And I think it's very interesting, and it's a recent tendency.
Yeah, and very welcome, obviously, for applicants. You know, an example of the court sort of proactively trying to deal with as well the numbers of cases and the workload, but in a sort of positive way for the individuals. Question we've got from Anirudh Mathur, Matrix. Question to Dr. Sartori. Has Strasbourg learnt the lessons from its passivity in the ECHO defence case? And do you think they will be more alive now to the speech with which civil society can disappear under authoritarian threat?
Yeah, I was reading that question. I really don't know the answer. What I can say in general is that, and this is valid for all the cases where it's not a traditional interim measure, it's not a traditional topic for interim measure. They are very delicate politically, and the court tends to be quite it has its hands tied somehow, because I mean we all see the increasing amount of criticism that international courts and tribunals are facing in general. So the more we go to the level of a political topic, the more backlash is possible to have, you know, for an interim measure. So this is my comment, but then I can't say more about the court. I'll just post in the chat an interesting article, academic article on the topic of non-traditional interim measures.
Yeah, and from the side of the Human Rights Committee, as I said, the Lula precedent, to a certain extent, so it was before I arrived in the committee, but the Lula precedent was really difficult for the committee because it was widely publicized and so on, and the committee was targeted as being politicized and so on. So now the Secretariat is very cautious before, you know, going beyond interim measures dealing with removal from territory. But in relation to freedom of expression, freedom of speech, freedom of association, so far we have not received this kind of interim measures request, but quite recently we had an interesting request dealing with the obligation that was made to a journalist to disclose his sources. And it was really imminent. So here we granted the interim measures because it was a domestic decision with this possibility of sanction of the journalist. So we granted the interim measures about the non-obligation to disclose the sources, because of course protection of sources is really an element, a very important element to freedom of expression and freedom of media. But again, it's really not frequent. It's like Daria said, very related to removal from territory cases.
I think I'm going to jump forward to a question from Jessica Gavron, because it relates to that last comment, Hélène. Jessica says, thank you for your excellent presentations. I'd be interested to know what you both think about a growing area of urgency, not traditionally recognised by the European Court, namely the real threat to democracy of repressive legislation and its abusive implementation. And Jessica gives the example of the decimation of civil society by the Russian foreign agent law. Is this a new category that the court and the Human Rights Committee should be prioritising in the current context? Daria, do you want to go first and then Hélène to follow up?
Yes, I think I'll go back to my prior comment in the sense that I'm a bit unsure about what is my position about this, because on the one hand, I realize that, and as a human rights defender, of course, I should be in favor, I am in favor of the idea of using, interim measures also to protect this kind of rights. But at the same time, I wouldn't want that this willingness, the legitimate willingness to use new interim measures might render the system fragile, as the system is already, looks to me at least, already quite fragile. So I'm really not sure whether it's a good idea, let's say, to use this instrument from a purely practical point of view, because I mean, in the words of the ideals, I'm totally in favor. But yeah, so this is my sorry if it's not very if it doesn't go too much in depth. I leave the floor to Hélène.
Yeah, my view would be a bit different because when I compare, for instance, the practice of the European Court of Human Rights with the practice of the Inter-American organs, I truly prefer the practice of the Inter-American organs because their interim measure, in terms of interim measures, because the material scope of their interim measures, it's much broader because the purpose also of the interim measures is different. So I would love to see the Human Rights Committee following this very generous approach of using interim measures, not only in cases of removal from territory, but also, again, as I said, protection of journalists, protection of civil society, and so on and so forth. So each time as special rapporteur, I have had the opportunity to try to go beyond traditional right to life, prohibition of ill treatment in case of non-refoulement. I really tried to follow this path. Now I fully agree with what Daria said also. So we have to be realistic because again, we are practitioners and there's pushback. Indeed, states do not like when human rights organs especially decide the suspension of a draft law, for instance, or immediate release of someone and so on and so forth as an interim measures. And second, indeed, I mean, there's also lack of resources. We cannot, if we open that way the scope of interim measures, so not only to traditional removal from territory, but also to protection of civic space and climate change, environmental pollution, new challenges, armed conflict, and so on and so forth, I'm afraid it will really grip the system. And here, yeah, it might be counterproductive. Yeah, I agree also on the conclusion.
And this is, I think, a sort of related question. This is from Gemma Gigardes Gonzalez, saying thank you very much for your amazing interventions. Question for Professor de Gruyter, have you developed any strategy to identify attempts to politicize interim measures? How do you communicate in this scenario to prevent the interested party from spinning the rejection of priority to present the Human Rights Committee as ineffective?
We do not have, I would say, a communication strategy for sure. So if applicants or authors are not happy with the decision, so and we are criticized, so we just do not say anything. But yes, in general, again, based on the Lula precedent, now when we receive interim measures related to political rights, right to vote, right to be elected, so Article 25 of the Covenant on Civil and Political Rights, we are really reluctant and we are extremely prudent, precisely because one thing we do not want to do is to enter into the political game of applicants. So we are receiving, I would not say more and more, but several interim measures requests depending on electoral calendar. So in this case for us, it's really a red flag. And we say, okay, when it's in relation to Article 25 political rights, we might presume that, yeah, there's probably a purpose for using, politicizing the interim measures requests. But yeah, we just reject, saying that the conditions are not met, but that's it. I mean, and then if we are criticized because we are ineffective, etc., I mean, never mind.
Great, thank you. I mean, one further difference seems to me between the two systems is that in the European Court, the initial review of the interim measure application will be done by a unit, a non-judicial unit. Whereas I understand, Hélène, from your presentation, that straight away you're getting people who are fully legally qualified and judge involvement. And of course, that may impact on the quality of decision making. I'd be interested to hear both of your views on whether we need to be concerned, or whether the European Court itself is it thinks it's an issue that it has this initial scrutiny. Maybe it doesn't, but what impact that has on quality of decision making. Gloria, do you want to go first?
Yeah, it's true that for the Human Rights Committee, the decision is taken by the special rapporteur on behalf of the committee. So it's a decision of the committee to grant or not to, or to reject an interim measures request. And it's, yeah, I mean, we try again to follow the conditions and the threshold and so on and so forth. And also it has to do with Jima question. We used to sign in the past the letter with the name of the special rapporteurs, but because we were targeted, insulted in social media and so on, now it's a decision taken by the Secretary General of the UN. So now the letter is signed. But yeah, but members of the committee and special rapporteurs are involved in the decision.
Yes, very interesting. I didn't know. Helen. No, for the European Court, I just would like to clarify. So I mean, a decision is taken by a judge, be it a duty judge or be it the chamber sometimes even. So it is taken by the court. It is true that first it goes to the scrutiny of a centralized unit. Basically, it has been created, the Rule 39 unit, which is composed still of legal professionals. So the difference being that they are not judges, so they are not elected by the Parliamentary Assembly of the Council of Europe, but they have been hired further to a public examination. So actually, on the opposite, I would say that this grants a high quality of the legal reasoning behind it. Actually preserves independence in a way, because it's not only judge's decision. I mean, it is a judge's decision in the end, of course, but first they get the view of persons who are super specialized in migration matters rather than the other matters, and have an overall view of the practice of the court on interim measures, and are completely independent from any political pressure of any possible kind. I mean, not that the judges are subject to those kind of political pressures, hopefully, but at least there is no political interference possible because these persons have not been appointed by a political nomination. So personally, I think it actually strengthened the court's overall functioning, this bipolarity between the registry and the judges, in which the whole registry is a body which is actually fully independent because composed of lawyers who are hired further to public examination. I don't know if this replied, Samantha, to your question.
No, great, thank you. And I'm just looking at the time because we've actually, we're just at 6 o'clock. I wanted, Başak, whether you wanted just to add anything at the end. I'm just going to say a very, very few concluding remarks, but
Well,
please.
Thank you very much. I mean, this was a very enlightening conversation for me as well. This was very helpful. One of the I think key themes that emerged from the conversation, if we go back to that distinction I made between the urgency for the victims and the applicants versus the urgency of subject matter. And I think in some of the conversations, we've seen that these may also be slightly in tension because, some of the questions that came about the urgency in relation to certain practices of shutting down organizations and NGOs have huge ramifications for a lot of individuals and their rights, but not immediately, perhaps not in the coming 72 hours, but definitely in the coming 72 months, I would say. So I think this is a really important matter to navigate. And we've also seen that the European Court and the UN Human Rights Committee, as well as Hélène kindly mentioned, the Inter-American Court, have very different approaches. Whereas the Strasbourg is trying to more focus on the urgency for the individuals, the others seem to have a very different way of thinking about this. So this was absolutely fascinating and very insightful to think comparatively also about how we handle questions around urgency. Thank you.
Thank you, Başak, and thank you both, Daria and Hélène. It's really been helpful having your insight on an area which isn't that easy to discern exactly what is taking place in practice on the ground. We all have our own sort of specific experiences of individual cases, but getting that wider picture is not so easy. So a huge thank you to the Bonavero Institute and to Matrix for hosting, and to our speakers, Başak, Daria and Hélène. And thank you to all of you for engaging, bringing your questions. You'll be sent details of the remaining 3 webinars in the series, but just to give you a heads up, the next one is Wednesday, 2nd of April, at 1 p.m. on litigating against authoritarian regimes, sadly all too relevant. So thank you all very much and good evening.